You pay your premiums, you stay in network, and you get the procedure your doctor ordered. Then you look at your phone and see a notification for a $42,000 medical bill. It feels like you've been hit with a financial penalty you can't possibly pay. That denial letter looks final. It reads like a binding verdict. In reality, it is a standard administrative strategy used by insurance companies to protect their margins. A large portion of these initial denials are generated by automated software algorithms, not actual doctors. To beat that algorithm, you have to stop treating the denial as a personal failing. Treat it exactly for what it is, a standard civil dispute. You take the emotion out of the process and you fight back with paperwork. This shows your two-tiered roadmap for fighting back. First, you enter the Level 1 internal loop, where you appeal directly to the insurance company. If they still say no, you break out into the Level 2 external path, taking your case to an independent reviewer. The math is heavily in your favor if you complete these steps. Data shows that a significant majority of patients who formally push through the appeals process end up getting their care covered. By initiating a formal appeal, you force the insurer to justify their algorithm with actual medical evidence. You turn their automated no into a negotiation. Step 1 is pulling your explanation of benefits. Look directly below the alert red claim denied stamp for a specific phrase like not medically necessary or experimental. That phrase tells you exactly what you need to disprove. The date on that document starts a strict statutory clock. In most cases, you have exactly 180 days to file your appeal before the denial becomes. Before you write a single word of your appeal, call your insurer and request your complete, unedited claim file. You want the internal notes from whoever or whatever reviewed a case. Under both state and federal law, the insurance company is required to send you this entire file for free. You do not have to pay to see the evidence they are using against you. Once you have their notes, your goal is to meet a specific legal standard, known as the preponderance of the evidence. This is the rulebook for your dispute. This visual represents the civil standard. In a criminal court, you have to prove things beyond a reasonable doubt. But here, the scales of justice only require you to prove it is more than 50% likely that your treatment was medically necessary. You just need to hit 51%. Ask your doctor for a letter of medical necessity tailored specifically to the denial code we found earlier. A certified physician stating why you needed this exact procedure easily clears that 51% bar. You don't need a corporate law firm to win. A targeted, documented medical opinion mathematically outweighs a billing department's technicality. While you are building your case, the billing department isn't waiting. They will often send your unpaid balance to a third-party debt collector, adding pressure while your appeal is still pending. This is where you activate the Fair Debt Collection Practices Act, or FDCPA. It's a federal law that gives you the power to freeze collection efforts during an active dispute. Send a formal, certified letter to the collection agency stating that the debt is currently in dispute. The moment they receive that notice, they are legally required to halt their aggressive tactics until the dispute is resolved. With the collections paused, finalize your Level 1 internal appeal letter to the insurer. Keep it factual. Cite their specific policy language and attach your doctor's letter. Leave out the frustration. Even with perfect evidence, the insurer might still say no. They are acting as the judge in a financial dispute where they are the ones losing money. If they reject your internal appeal, you escalate to Level 2. This flowchart shows your case moving away from the insurance company entirely and into the hands of an independent external review or an administrative law judge. Administrative law judge tribunals, they look only at your doctor's evidence and the 51% civil standard. They do not factor in the insurance company's quarterly profit margins. Because insurers know they will likely lose in front of an objective judge, simply requesting this external review often forces them to settle the claim and pay your bill. Let's review your final submission. You have the unedited claim file, the targeted letter of medical necessity from your doctor, and an emotionless, fact-based dispute letter. You have also established a dual-layered defense. The federal debt collection laws are holding off the bill collectors, and the threat of an independent judge is keeping the insurer in check. Instead of reacting to an automated system with panic, you are now operating as an informed claimant wielding federal rights. By treating a denied claim as a standard civil dispute, you strip the insurance company of its home field advantage. That staggering medical bill goes from an inevitable crisis to an argument you are fully equipped to win.